Is the definitive account of all the news events and developments that have shaped your world today. So, let's get started. No merit. That's the view of the NPA regarding the authenticity of Docket 375. This so-called second docket implicates those who were in the house on the night Senzo Meyiwa was killed. Advocates Defu and Mshololo, who are acting for the accused, meanwhile, disagree on a postponement regarding the matter, and there were angry exchanges between the judge and defense lawyer for accused 1 to 4. Here's ENCA's Silindelo Masikane with that story.
Court proceedings resumed with the state handing up letters claiming that Docket 375 was an internal opinion from a junior advocate which has no merit. But Advocate Zandile Mshololo says she still plans on using it during cross-examination.
The state had a legal duty, my lord. It is not a favor. Accused number 5 constitutional right has been violated. To such an extent that, my lord, had we known about the existence of this docket, we will not have pleaded as we have pleaded. And right now we are in a predicament that we are unable to conduct our defense further as a result of this late disclosure of the police docket. The state knew about this docket, my lord, and neglected or decided not to disclose it to accused number 5, and thereby violated the accused number 5 constitutional right. And that on its own, my lord, amounts to a miscarriage of justice.
While Advocate Mshololo needs a lengthy postponement to consult on Docket 375, Advocate Malisela Defo for accused 1 to 4 says his client's constitutional rights to a speedy trial are being ignored, getting into a heated exchange with the judge.
Your Lordship, I still feel grief as accused 1 to 4 that we are definitely being excluded from these proceedings by this court.
Okay.
But there are very
if
material
you are not going
issues.
to respond to what I asked you, sit down. Sit down, Advocate Tefo. If you are not going to address dates, sit down.
I cannot be forced.
Unless you want to be in contempt of this court. I asked you a specific question. If you are not answering me on that, sit down.
Lordship, the best way, let's go to the chambers.
No, I'm not going to the chambers. About you trying to undermine me in court. I'm not going to any chambers.
But now the accused 1 to 4 has been undermined here. We cannot prolong this case.
Sit down.
Yeah.
Advocate, sit down.
Therefore has once again raised the issue of jurisdiction. He's questioned the authenticity of the letter giving the North Gauteng permission to preside over the trial, alleging that due process was not followed. Defo insists that the National Director of Public Prosecutions needs to come and explain.
We came to realize a material defect which does not give this court a jurisdiction to hear and grant the application contemplated by Advocate Mshololo. The jurisdiction of this matter is a common cause that is under the local division South Gauteng in Johannesburg. And as we stand before this court, the procedure in terms of the Minister of Justice to give this court a jurisdiction has been grossly violated.
Judge Maumela has requested formal heads of argument to be filed around the issues that have been raised. Court proceedings resume tomorrow, where we expect a date to be finalized for arguments to be heard on the issues of jurisdiction and when the trial can officially resume. Silindelo Masikane, Pretoria.